Good evening to all esteemed dignitaries, respected speakers, faculty members, scholars, members of the press and participants. With a heart full of gratitude, we, Kritika and Abhinav, warmly welcome you to the Valedictory ceremony of the National Conference on Indianization of Legal System, organized by the Center for Public Policy and Good Governance of the Dr. B.R. Ambedkar National Law University, Sonipat, in partnership with Association of Indian University, the Akhil Bharatiya Adhivakta Parishad, Haryana Prant, the Indian Law Institute, Delhi, National Law University, Delhi, the Rajiv Gandhi National Law University, Patiala, Dr. Ram Manohar Lohia, National Law University, Lucknow, and the National Institute of Electronics and Information Technology, Government of India.
Throughout the conference, with numerous paper presentations in 3 technical sessions, our deliberations have been nothing short of enlightening. We were privileged to witness an exceptional confluence of minds. Judges, advocates, bureaucrats, academicians, legislators, and domain experts, whose insights enriched every session of this national conference. Their diverse perspectives sparked vibrant conversations, bridging the realms of theory and practice in the most meaningful ways. As we now step into the final segment of this conference, let us reaffirm our shared vision to make the Indian legal system more accessible, relevant, and rooted in our own unique civilizational context.
On that note, with utmost sincerity, we extend a warm welcome to all dignitaries on the dais. The chief guest, Honorable Mr. Justice N. Kotiswar Singh Ji, Judge, Supreme Court of India. Special guest of honor, Honorable Mr. Justice Pankaj Jain Ji, Judge, Punjab and Haryana High Court. Special guest of honor, Honorable Mr. Justice Meenakshi Mehta Ji, Judge, Punjab and Haryana High Court. Special guest of honor, Honorable Mr. Justice Indrajit Mehta Ji, Judge, Punjab and Haryana High Court. Special invitee, Dr. Pawan Duggal Ji, Advocate, Supreme Court of India, Chief Executive, Artificial Intelligence Law Hub. Patron-in-Chief, Shri Ashok Kumar Ji, Honorable Vice Chancellor, Dr. B.R. Ambedkar National Law University, Sonipat. A Conference Director, Professor Dr. Ashutosh Mishra Ji, Registrar, Dr. B.R. Ambedkar National Law University.
As we begin this auspicious valedictory ceremony, we invoke the spirit of wisdom and knowledge. May I request our esteemed dignitaries on stage to grace the occasion and perform the lighting of the lamp.
जाड्यान्धकारापहा हस्ते स्फाटिकमालिकां विदधतीं पद्मासने संस्थितां वन्दे तां परमेश्वरीं भगवतीं बुद्धिप्रदां शारदाम्।
Before we proceed further, let us take a moment to honor the values of our institution. I request everyone to rise and join in reverence as we present the Kulgeet.
शुभ न्याय मिले अन्याय टले, शुभ न्याय मिले अन्याय टले, ओ सत्यमेव जयते। जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते। कर्तव्य भाव की हो दीक्षा, मौलिक अधिकारों की रक्षा, मानवता धर्म निभाने की जन जन को सुलभ रहे शिक्षा। इसको पाने के लिए सदा हम धर्म मार्ग चलते। जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते।
I now request Dr. Pooja Jaiswal, Dean of Academic Affairs and Head of the Department, whose strategic guidance in planning, organization, administration has made this conference a huge success, to deliver the conference report. Please welcome ma'am with a huge round of applause.
A very good evening to one and all present here. Dignitaries on the dais, Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. Honorable Mrs. Justice Meenakshi I. Mehta, Judge, Punjab and Haryana High Court. Honorable Mr. Justice Pankaj Jain, Judge, Punjab and Haryana High Court. The Honorable Vice Chancellor, Shri Ashok Kumar Ji, Shri Pawan Duggal Ji, and the Registrar and the Conference Director, Professor Dr. Ashutosh Mishra Ji. Esteemed scholars, distinguished guests, faculty members, students, and the staff, and to all those who have contributed to the culmination of this conference, which talked about Indianization of the Indian laws. When we talk about the legal system, it contributes to each and every individual. And today, when I stand before you to read the report of how this conference happened throughout the day, I take immense pride and I stand here with gratitude that today the conscious approach with which we designed this conference, giving a platform where principles and procedures, democratic values, the Bharatiya principles, which form the bedrock of our democratic ethos, and how to delve this further with modern technologies. I firmly confirm that we have tried to meet all these objectives. In the day-to-day from the inaugural session, we had 9 technical sessions, 3 sessions running parallelly in the offline and the online mode. And we dwelled upon the 3 major themes of this conference, that is Bharatiya Nyaya Shastra, new criminal laws, and use of technology in adjudication. These sessions were presided over by resource persons from the judiciary, government institutions, PSUs, advocates from the Supreme Court and High Court, faculty members, who in the entire day, in various technical sessions, embarked upon the foundational principles of ancient Indian jurisprudence, such as dharma, justice, and ethics, and their relevance in addressing contemporary legal challenges. I feel elated to announce that we received an overwhelming response to our conference, where more than 200 abstracts were submitted. And these abstracts were carefully selected by the editorial team through rigorous review process. And today in the day, around 90 abstracts that were shortlisted, which were presented in the various technical sessions. A compilation in the form of book of abstract was released in the inaugural session that reflects the rich spectrum of ideas and research that aim to explore and contribute in the evolving discourse of shaping a legal system, and which would be India's unique sense, in the sense imbibing historical, cultural, and societal context. We commend and are thankful to all the contributors for their thoughtful work. In the technical sessions, we have also witnessed certain critical evaluation that how these new criminal laws would transform the justice delivery system in the country. Presenters focused their deliberations on integrating indigenous legal traditions into modern jurisprudence to create a justice delivery system more accessible to all sections of society. In the third technical session, the technological aspect was highlighted, where tools like SUPAS, SUVAS, and AI in enhancing judicial efficiency, transparency, and accessibility within the Indian legal system. And also, innovative suggestions came from the resource persons. A lot of emphasis was also given on the speedy justice delivery and also focusing on community service and restorative justice. Thus, I would say that the day-long deliberation targeted in dwelling innovative views of and ways of blending traditional jurisprudence and contemporary legal practices to address emerging challenges. I would also like to mention that some papers also dwelled into the realm of environmental ethics, drawing from Vedic reverence for nature to purpose or achieve the goals of sustainable development, legal framework, and address ecological crises of the current times. The views and concerns raised by several young presenters, researchers, validly acknowledge the gaps that are required to be bridged. through the diverse paper presented today, this conference gave a platform to build an understanding of profound intersection between ancient India and the modern legal system. Our knowledge partners, the ILI, the Akhil Bharatiya Adhivakta Parishad Haryana Prant, Association of Indian Universities, National Law University Delhi, Rajiv Gandhi, National Law University Punjab, the Ram Manohar Lohia National Law University Uttar Pradesh, and National Institute of Electronics and Information Technology, Government of India, have contributed immensely to this event. We are thankful to our knowledge partners. To sum up, I would say that through this discourse, we look forward to promote a more inclusive, sustainable, and justice-oriented approach to legal system in the 21st century, and to ensure that our legal system evolves in harmony with both rich past and our dynamic present. This is not just the end. Today, the deliberations have been opened. The road ahead may be long, but your dedication and passion will succeed us in building a legal system that is ours. And with this, I would thank all of you for your valuable contributions. I would thank the Honorable Vice Chancellor, sir, for his guidance and the support that he has shown throughout this event, and the conference director for his commitment towards enriching the students with the Bharatiya Nyaya Shastra. Thank you so much.
Thank you, ma'am. Ladies and gentlemen, it is my privilege to welcome our Honorable Vice Chancellor, Shri Ashok Kumar Ji, whose leadership and vision have initiated multiple endeavors such as the present conference in the university. Please give a huge round of applause to welcome the Honorable Vice Chancellor.
Namaste and good evening to all. Honorable Mr. Justice Sri N. Kotiswar Singh, Judge Supreme Court of India, Honorable Justice Meenakshi Mehta ma'am, Honorable Justice Sri Pankaj Jain sir, both Judge Punjab and Haryana High Court, esteemed scholars, delegates, distinguished guests, faculty members, and dear students. As we draw the curtains on this intellectually stimulating gathering, I would like to appreciate the collective understanding of the profound intersection between ancient Indian jurisprudence and modern legal systems that we have seen and heard all through the day. At the heart of our discussions has been a singular transformative idea, the integration of Bharatiya Nyaya Shastra, rooted in the timeless principles of Vedas and Dharma, into the fabric of contemporary Indian law. For too long, our legal system has operated under the shadow of colonial legacies, for almost 150 years, shaped by frameworks that, while functional, often feel disconnected from the cultural and philosophical ethos of our nation. This conference has served as a powerful platform to challenge that disconnect, to critique the colonial foundation of our legal institutions, and to advocate for a justice system that resonates with the values of Dharma, a concept far richer and more holistic than any Western counterpart. Dharma encompasses righteousness, duty, moral law, and cosmic harmony. It's a combination of duty, morality, and law, one single word. Moving further, we have delved into the wisdom of Vedic jurisprudence, which emphasizes restorative justice, mediation, and ethical adjudication, principles that stand in stark contrast to the adversarial and punitive model inherited from colonial rule. These ancient ideas, as we have seen, are not mere historical artifacts, rather, they offer practical solutions to some of our most pressing challenges. From decongesting courts to fostering community based dispute resolution. The path to Indianizing our legal system is not without obstacles. Infrastructural deficits, judicial backlog, and the risk of superficial reforms loom large. True transformation demands a deep philosophical engagement with our civilizational values, coupled with sustained institutional support and public awareness. The success of this endeavor will depend on our ability to translate these ideas into actionable policies, to bridge the gap between intent and execution, and to ensure that our legal system evolves in harmony with both our rich past as well as our dynamic present. But let me be clear, this conference is not the end of our journey, it is the beginning. The ideas shared here, the dialogues initiated, and the visions articulated are the seeds of a profound transformation. We stand at the threshold of a new era in Indian jurisprudence, one where legal system can be both authentically Indian and universally just. We can have a mix of both the Indian wisdom as well as the Western modern ideas. By reclaiming dharma as the moral compass of our justice system, we can inspire a model of law that balances tradition with innovation, equity with efficiency, and individual rights with collective harmony. The recent legislative efforts with 3 new criminal laws, that is the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksha Adhiniyam, represent a historic move towards decolonization. These new codes seek to make criminal justice more citizen-centric and culturally contextual. These highlight a dynamic reimagining of justice in India that is culturally rooted, constitutionally sound, and technologically equipped for the future. At the center of new laws is the delivery of justice and not punishment. As we all know, Indian Penal Code has been changed to Bharatiya Nyaya Sanhita. At the center of IPC was penal, Dand, Bharatiya Dand Sanhita. Now at the center of the new Bharatiya Nyaya Sanhita is justice, Nyaya. So there is a big shift. Names matter a lot. Names matter a lot. So there is a big shift from being punishment centric to justice centric. It focuses on time bound justice. As justice delayed is justice denied. Though being a former DGP, I have very apprehensions whether these timelines will be able to follow or not, because the timelines are very strict. Even for police, following those timelines for investigation is not easy. Similarly, I don't think it will be easy for judiciary also to follow the prescribed timelines of trial and judgment. New laws are closer to Indian ethos as their focus is on videography of search and seizure and use of forensic tools so that truth prevails. I have served in UP also, and we all know, when we used to investigate, there was always an element of doubt. Now, with videography of search and seizure and all dependence of forensic evidence, I am sure truth will prevail. It has also included community service as a punishment, which was prevalent in Indian system of panchayat, which is an example of restorative justice. The legal system needs to use Indian languages so that the victim and accused both understand what is going on in the court. Because this has been observed, they feel just as if they are not a party, while they are the people who need to understand what is going on. But they always see it's a fight between the advocates. So, I strongly profess that laws should be in vernacular language, Indian languages, so that it is within the reach of each and every person, each and every citizen of this country understand the same and could take necessary remedy under the law. The purpose of law can only be served the best when they are in our own language. Hamari mitti, hamari bhasha, hamare kanun. That should be the motto. in the inaugural session, I raised one point. So those people who are common, they will realize, because one aspect I felt very strongly as an IPS officer all through my life, there is a big need for changing laws regarding marriage. At present, the marriage age is 18 years for the girl and 21 years for the boy. They can marry at their own will, which is against the Indian ethos, which is against the Indian social system. Because in India, children are not independent like Europe and USA, where children, as soon as they become 18 years old, they can leave the house. They start living independently. So we are imposing a foreign culture, foreign ethos on our system, where the married people stay with the parents. It's not a marriage of just two individuals. It's a marriage of two families, bonding of two families. So we have to be sensitive towards that. Therefore, my personal feeling is that at the age of 18 and 21, I cannot decide even my career. How can I decide about my marriage? So marriage is, at least the children should be at least 25 years of age before he or she can decide whether she is marrying the right person or not. Till the age of 25, the marriage should be done with the consent of parents. This is my idea. Because with the present system, lot of litigation, lot of crime is happening, because at the age of 18, the girl is really not in a position to decide whether she is going with the right person or not. I am grateful to our Chief Guest, Justice N. Kotiswar Singh, sir, for accepting our request and giving new heights to this conference. University is really honored to have you as Chief Guest, sir. My sincere thanks to our guest of honor, Madam Meenakshi Mehta, and Sri Pankaj Jain, sir, Honorable Judges of Punjab and Haryana High Court. I am also grateful and thankful to our participants and also to our knowledge partners and everyone who has come in collaboration with us today for this important event. I am confident that the deliberations today will inspire all participants to carry forward the torch of Bharatiya values, Bharatiya Nyaya Shastra. Thank you all.
Thank you, sir, for your warm welcoming words. It is my honor to introduce our special invitee for the valedictory ceremony, Dr. Pavan Duggal, Advocate, Supreme Court of India, and Chief Executive of Artificial Intelligence Law Hub. A pioneer in cyber and AI law, Dr. Duggal has been instrumental in shaping India's digital legal landscape. Sir, we are privileged to have you with us today and eagerly look forward for your insights.
Honorable Justice Singh, distinguished dignitaries on the dais, ladies and gentlemen. Thousands of years back, India became the cradle of civilization. At the time when the West was still in the Western wilds, India had already given two important concepts to the world. One, the concept of zero, which ultimately became the foundation for technological advancement globally. And the second, the concept of Vasudhaiva Kutumbakam, the world is my one family. As we went across centuries, we found that the Indian legal jurisprudence evolved from the time of Ashoka, the time of Chandragupta Maurya, to the Mughals, and then to the British times. The Indian legal system, recent few centuries, were primarily inspired by the British. When we got independent, the Constitution of India became a living document, which guided us on how we need to evolve our ecosystem. But then while all this was happening, Internet happened. Internet, a paradigm which made geography history. Internet, a paradigm which never sleeps. Internet, a paradigm which never forgets. And this Internet, which got commercially introduced in the country on 15th of August 1995, has become the center point of our lives. You cannot today envisage your life without the Internet today. That's the current dependence on the Internet. But then again, things were happening. Came 30th of November 2022. That's the day ChatGPT gets launched. The world changes dramatically and irreversibly. everybody begins to start running on to generative AI. So today, generative AI actually is commanding our lives at a time where people are going to generative AI for romantic advice for troubling their parents, for advice on human relationships. The time has come that we need to look at how technology can be used for the purposes of Indianizing the legal system. Well, in February 2025, the Prime Minister Narendra Modi went to the AI Action Summit in Paris. And there, for the first time, he gave a concept, the Indian concept to the world, which nobody talked of earlier, the concept of sustainable AI, where he married the concept of artificial intelligence with sustainability. While all this is happening, when we are trying to Indianize the legal system, I need to be cognizant of what's happening globally. Then try to not do a cut and paste, but try to identify the experiences therein and Indianize. So last week, El Salvador has become the latest country and the first country in Latin America to come up with a law on artificial intelligence. Last week, the UAE has announced that they will now officially be using artificial intelligence for creating legislative frameworks and for weeding out old laws. So in a scenario like this, when we are looking at Indianizing the Indian legal system, I had a couple of thoughts which I wanted to present for everybody's consideration here. First and foremost, let's be very clear, technology is going to change things completely and in the next few years. With quantum computing coming in, I think we are already in for an irreversible change. So I'm anticipating a national quantum judiciary network in India, a network that's going to be powered by quantum computing, where complex legal propositions can be broken down to the simplest possible levels, then presented to human judges so that this particular information can be used extensively for quickly and expeditiously deciding matters. The second issue that I'm looking at, a potential possibility, is that of virtual Indian Nyaya Panchayat. The Indian legal system has already been based on the Panchayat ecosystem. Now, today Panchayats are matter of history. It's time that we should go ahead and revive the concept of Panchayats, but power them with technology. How about virtual Nyaya Panchayats who are powered with augmented reality and virtual reality, so that a litigant can go to this virtual Nyaya Panchayat and lo and behold, his problems can be sorted out at an earlier level, much before it goes to court. The third thing, blockchain is actually, shall I say, maturing very, very rapidly. In Andhra Pradesh, we are already saving all the land records and the land pattas on blockchain. I'm very quickly going to be seeing a scenario where the Indian judiciary is likely to save all its judicial records, electronic records on blockchain. And there could even be a decentralized autonomous courts which could be powered by blockchain as we go forward, while marrying the Indian concepts, but also equally adopting to technology. And finally, we talked of Bharatiya Nyaya Sanhita, the Bharatiya Saksha Adhiniyam, the Bharatiya Nagrik Suraksha Adhiniyam. How about the Bharatiya Nyaya Network? This is a new network that I'm envisaging, where it will help democratize the access to justice and the access to technology, where today, right now, people only have access to judgments. People only have access to video conferencing. How about if they have access to legal education, to their options available? How about providing them through technology the ability to get their problems sorted out using technology in an efficient and expeditious manner? If we do any of these four or all four put together, it's going to have a massive constructive effect on reducing the quantum of pendencies in Indian courts, and finally is going to make Indian judicial ecosystem far more forward-looking and futuristic. Let's realize that we have no longer just become the largest democracy in the world, we're also now the most populous nation in the world. So what India does will to a large extent become an international gold standard, an international benchmarking standard for other countries to follow. So if we can start doing these Indianization of legal systems using technology, to a large extent, we can contribute in building a much secure, robust and resilient judicial framework and cyberspace India. Thank you, ladies and gentlemen.
Thank you, sir, for your enlightening address. We are grateful for your time and the knowledge you shared with us today. Thank you, sir. Ladies and gentlemen, esteemed delegate and dignitaries, As we continue to bask in the glow of intellectual enlightenment, we are honored to introduce our next distinguished guest speaker for today's conference. One whose presence functions as a foundation for the thought and our discourse on law and justice. With great anticipation and reverence, we extend a warm welcome to our esteemed special guest of honor, Honorable Mr. Justice Pankaj Jain, Judge, Punjab and Haryana High Court. His Lordship was appointed Senior Panel Member by the Government of India in 2014. His Lordship was appointed Senior Standing Council Member to represent the Union Territory of Chandigarh in 2018. Further, in May 2021, His Lordship was designated as Senior Advocate by the Punjab and Haryana High Court, and in October 2021, His Lordship was elevated to the bench as an additional judge of the Punjab and Haryana High Court. His pursuit for justice has been exemplary, and his judgments are testament of it. Please join me in extending a heartfelt welcome to His Lordship. Can we have a huge round of applause?
Honorable Mr. Justice and Kotiswar Singh, dignitaries on the dais, off the dais, and dear students, I'm thankful to the Vice Chancellor and the organizing committee for having called me here on this wonderful topic of Indianization of legal system. The day I was told that I have to be here, I wondered as to what is the need for this. Do we think that the legal system is not Indianized? In fact, we have been educated, we have been seasoned to think that prior to the colonizers gave this legal system to us, we were an unorganized country having no legal system. In 2023, I had an occasion to travel to London. I went to Lincoln Castle. There is an original copy of a Magna Carta preserved over there. Being students of law, we all here are students of law, we all are aware what Magna Carta is. But what surprised me was the way it has been displayed. It was mentioned Magna Carta, law, liberty, legacy, the foundation stone of a legal tradition that governs a third of the world's population. And that included, there was a map, global, which included India also. Now this is what the displayer has to display. There is another version that a researcher had to give. John D. Maines wrote a wonderful treatise on Hindu law that is quite oftenly cited by the scholars, by the jurists, even in the judgments passed by various High Court, Supreme Court. Now, what John D. Maine had to say about the Hindu jurisprudence. I quote from John D. Maine what he wrote in the first preface, to his first edition. I am quoting him. He said, Hindu law has the oldest pedigree of any known system of jurisprudence. And even now, it shows no strength of decrepitude. At this day, it governs races of men, extending from Kashmir to Cape Comorin, who agree in nothing else except their submission to it. No time or trouble can be wasted, which is spent in investigating the origin and the development of such a system and the causes of its influence. I also hope that the same discussions, which appear to have only an antiquarian and theoretical interest, may be found of real service, if not to the counsel who has to win the case, at all events to the judge who has to decide it. Now, this is the legacy that a researcher found in the Hindu jurisprudence. Whenever we are told that there is a rule of law, we oftenly found its traces, or we oftenly try to find its traces in the Western jurisprudence. Ignorant of the fact that thousands of years back in India it was said, Tadetat kshatrasya kshatram yadharma, meaning, who is the kings of king? It is dharma, the law. Tasma dharmatram nasti. No one is superior to the law. Now, this is the legacy that we have. And this legacy, our foundation fathers were aware of. When Constituent Assembly was drafting Constitution of India, I quote from member of the Constituent Assembly, his name was Jaipal Singh Munda. On 19th of December 1946, in the debate, he said, the history of the Indus Valley civilization, a child of which I am, shows quite clearly that it is the newcomers. Most of you here are intruders. As far as I am concerned, it is the newcomers who have driven away my people from the Indus Valley to the jungle fastness. The resolution is not being to teach Adivasis democracy. You cannot teach democracy to the tribal people. You have to learn democratic ways from them. They are the most democratic people on earth. What my people require, sir, is not adequate safeguards, as Pandit Nehru has put it. They require protection from ministers. That is position today. We do not ask for any special protection. We want to be treated like every other Indian. Now, this is the civilization we belong to. This is the ethos, this is the legacy that we have inherited. And this is something that we need to realize. The day this realization will come, this system will be Indianized. You played your anthem, Satyamev Jayate. What is the objective of the legal system? The pursuit for justice, the pursuit for truth. And this is what centuries ago our forefathers said, Satyamev Jayate. You will be surprised to find that the first national anthem finds mention in Yajur Veda. There is a very interesting tale that there was Devasut Sangram. There was a struggle between Devtas and Asurs. So the Devtas, they thought, why we are losing repeatedly? So they held a meeting. They realized that though each of one is very powerful, but there is no one to guide us. There is no one who is our mentor, who can lead us. So together they elect their leader. And then that leader, he takes an oath. And the oath is again the same, free of ill will and hatred. You may not believe that. We may say that it's questionable whether historically it happened or not. But the fact that thousands of years ago someone wrote it, that shows what our legacy is, what our thought process is. We are the only civilization who has a river in our name, we have a mountain range on our name, we have ocean in our name. Just when I arrived here, we were discussing about all this. So Ma'am Meenakshi Mehta said a wonderful thing. I asked her, since she's here since morning, so I said, कि आपने फिर Indianize कर दिया legal system? So she said a wonderful thing, and I think that is the key. She said, that is here. That is all realization. I think we had a revolution that gave us independence. but we never had evolution. We need to have evolution. Indian system is already there. Our forefathers have given us, drafted wonderful constitution. The requirement is, the need is only to realize the ethos of our civilization and to connect to it. And to end, I will quote from the distinguished jurist that we have today as Chief Justice, Justice Kotiswar Singh. He said that the judges should write not for the higher courts, but for the general public. I think the same thing applies to the academicians and the jurists as well. Whatever they write, that should be written for the general public and not only for the classes, but for the masses. Thank you. Jai Bharati, Jai Bharat.
Thank you, Lordship. His Lordship's profound insights, having set the ball of spirited discourse into motion, make us eagerly anticipate the opportunity to gauge the prospect of our next esteemed guest. In the spirit of legal excellence and intellectual conquests, we now turn our attention to the address by our esteemed special guest of honor, Honorable Mrs. Justice Meenakshi Mehta ji, Judge, Punjab and Haryana High Court. Her Ladyship joined the Haryana Judicial Services in the year 1987 and in the year 2019 was elevated as a judge of the Honorable Punjab and Haryana High Court. Her Ladyship's judgment have largely impacted and transformed the society. With a keen eye for justice and a deep-rooted understanding of legal intricacies, Her Ladyship brings to her conference a wealth of experience and meaningful perspectives. Please join me in extending a very warm welcome to Her Ladyship.
Namaskar. A very good evening to everyone. Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. Honorable Mr. Justice Pankaj Jain, my fellow judge, who is just like a younger brother to me. Distinguished faculty, esteemed delegates, and dear students. It's with profound gratitude and immense honor that I rise to address this august gathering at the culmination of this intellectually invigorating national conference on the Indianization of the legal system. Through the course of this day, we have been privileged to witness the brainstorming sessions consisting of a dialogue between the tradition and transformation, where the speakers converged to contemplate the soul of Indian jurisprudence. Today, as we draw the curtain on this conference, we do not merely close a chapter, we ignite a new vision. A vision that calls for reclaiming the philosophical sovereignty of our legal system. As Justice P.N. Bhagwati once said, a nation's laws are but the mirror of its soul. Indeed, India's soul is ancient, textured, and resilient. And yet, as we stand more than 77 years into our independence, a gentle but persistent question has emerged. How Indian is our legal system, not in origin alone, but in its outlook, accessibility, and alignment with the lived realities of our people. This question is neither rhetorical nor adversarial. It's a call to reflect and consider whether the structures we have retained still serve the ends of justice in the diverse, dynamic, and deeply rooted society that is India. The idea of Indianization of the legal system is not a rejection of the inherited structures, but a clarion call for recalibration. It is about crafting a legal order that is accessible, inclusive, rooted in Indian realities, and responsive to Indian values. Indian legal system, as it stands, is a vestige of colonial architecture, majestic but often alien. The common law traditions we inherited were never intended to be the instruments of justice for the Indian masses. They were, in the words of Lord Macaulay, a mechanism to govern a population alien in tongue, in custom, and in tradition. The process of Indianization must begin by restoring the dignity and relevance to our legal system. Law schools are the crucibles in which the future of legal thought is forged. If we, as a civilization, are serious about Indianizing our legal system, the transformation must begin in the classrooms. We must teach the Indian Constitution not just as a document of rights, but as a living moral character shaped by Indian values and modern aspirations. In the words of Justice V.R. Krishna Iyer, law must not be an abstraction for the elite. It must be a functional reality for the poor, the marginalized, and the voiceless. As we conclude this remarkable gathering of minds and convictions, let us take a moment not merely to close a conference, but to open a deeper conversation, one that extends far beyond this hall into our courtrooms, classrooms, and the corridors of legislation. The Indianization of our legal system is not an end point. It is an evolving journey. It does not call for abandonment of foundational principles, but for their re-articulation in a voice that India recognizes as her own. It is a movement towards a jurisprudence that is not only technically sound, but also morally and socially responsive and culturally cognizant. The strength of any legal system lies not only in the brilliance of its laws, but in the depth of its empathy, the clarity of its purpose, and the faith of its people. May we, as the custodians of law, whether the judges, lawyers, scholars, or students, remain committed to shaping a legal order that reflects the soul of India, diverse yet united, ancient yet progressive, and traditional yet constitutional. Thank you. Jai Hind.
Thank you, ma'am. In the wake of a thought-provoking address by Her Ladyship, we express our utmost gratitude for her invaluable and enleveling words. Your depth of knowledge and clarity of thoughts are sure to leave a lasting impression on our discourse, inspiring us to delve deeper into the intricacies of this important intersection and setting the tone for a flurry of substantial ideas that are bound to come forth in the conference. We are sincerely grateful for the depth and breadth of wisdom you have shared with us. Thank you, ma'am.
As we eagerly anticipate the unfolding of the next chapter in today's valedictory ceremony, it is my great privilege to introduce our esteemed chief guest, Honorable Mr. Justice N. Kotiswar Singh Ji, Judge, Supreme Court of India. His Lordship's distinguished career, spanning advocacy in Supreme Court and Guwahati High Court, service as Advocate General in Manipur, multiple tenures as Acting Chief Justice in both Manipur and Guwahati High Courts, and more recently his appointment as Chief Justice of Jammu and Kashmir and Ladakh High Court culminated in his elevation to the Supreme Court on July 18, 2024, when he made history as the first jurist from Manipur to join our nation's highest bench. His Lordship's unwavering commitment to the rule of law, access to justice for underprivileged represented communities, and the seamless integration of regional perspectives into national jurisprudence have earned him respect from both bar and bench alike. His distinguished presence not only adds a touch of propriety to today's gathering, but also brings with it a wealth of experience and wisdom. His Lordship's leadership and vision have played an instrumental role in shaping the future of legal system of our country. Please join me in extending a warmest welcome to His Lordship.
डायरेक्टली सर नीचे कर देंगे Good evening, the assembled dignitaries on the dais, Honorable Justice Meenakshi Mehta ji, Judge Punjab and Haryana High Court, Honorable Justice Pankaj Jain ji, Judge Punjab and Haryana High Court, respected Sri Ashok Kumar ji, the Vice Chancellor of the University, and respected Dr. Pavan Dugal ji, expert in IP, others areas of law, and respected Professor Dr. Ashutosh ji, the Registrar of the University, and Madam Pooja ji, Dean of the Academic Affairs and HOD, and assembled dignitaries here, the faculty members, and my dear students. Yes, I brought all these papers before me because I am so impressed by this voluminous book in which wonderful papers have been presented, and various, especially the three aspects of the discourses on Bharatiya Nyaya Shastra, the new criminal laws, and the technological advancement. As I proceed to speak, of course, I am being oblivious to the dais and the first and second row, because all are sitting here more eminently suited to speak better than me. I am just a BA LLB. So you can see my the academic, the credential is much less than these PhDs and other scholars sitting here. So I won't be able to compete with them in terms of scholarship. But certainly, I can address the students from the experience of my life rather than my scholarship. Well, this Indianization of legal system, it is a very interesting subject, which in fact which I have been thinking since I became a judge. As a lawyer, of course, I didn't have much time to think over all these philosophical aspects of law. But as a judge, when you start judging others, things used to come in mind. Is it correct? Is it the best way to approach the problem? And we are in India. We have been all studying all, I don't know the curriculum, the current curriculum in LLB. We have 5 years courses, but at least during my time, we used to study mostly Western authors and say principles, interpretation of law, Maxwell, and all those, and jurisprudence also. The book jurisprudence. Hardly any Indian author, I remember, that Dias jurisprudence. They're all book. I don't know whether you are still studying that Dias jurisprudence. We used to study those. Well, and property also, the law of property, all based on Western concepts. I used to ponder, as mentioned by Dugalji, also just ancient civilization. At the height of civilization, actually, some of the brightest mind the human civilization has produced has walked on this earth, in this part of this land. I was in Jain for 1.5 years, and there's a hill, beautiful hill called Sankaracharya Hill. I don't know how many of you have been to Jain, Kashmir, Srinagar. A beautiful temple is there. Many people go. I had gone there several times also. And you have a picturesque view of Srinagar. Such a beautiful landscape from the top of the hill. There sat Sankaracharya, hundreds of years before. Where was Sankaracharya born? Can any student tell me here? I'm sure somebody must be from the south. Anybody from the south? Kerala? Adi Sankaracharya. He was born in Kerala. At a time we didn't have the great Indian railways. At a time we didn't have these Jet Airways, Indian Airlines, SpiceJet. Just imagine that this great Acharya coming all the way from Kerala went to Srinagar. I mean, to go to Srinagar, you have to pass through Banihal, this path, and all this, Pir Panjal range. It's a huge mountain which actually separates the Kashmir Valley with the rest of the country, the Pir Panjal range. You have to arduous. At that time, they used to trek for miles and miles. And this Sankaracharya not only went to Kashmir, he went to the east. In Puri also the Dham, that the west. In Gujarat and Rajasthan, that also we have this another Kanchi, all this. South, all 4 directions he established this math. What he proposed, he great proponent of Advaita philosophy, which is considered to be the highest form of philosophical attainment, the Advaita philosophy. Just imagine this country, vast. And I mean, in India today, how many states are there? In just states, how many languages are spoken? Different cultures. Imagine, it's such a wonderful country. So I was just thinking this Indianization of legal system. I brought this laptop because suddenly I remember that I had given a speech in Kashmir also when I was there. The subject was Bharatiya values and Indian Constitution. I thought I will just borrow a little bit of my own earlier work on that. When I say Indianization, what does it actually mean? It's basically, in my view, going back to the rich traditional values which we had, which most of us has forgotten. Nobody can be blamed in that sense because we had undergone this colonization. before that also invasion from other. See, it's a part of history. You can't blame anybody. History marches like that, So, but then India has mingled different cultures, different religious faiths, denominations, and still India retains the core Indianness somewhere. It's very difficult to define actually also. What is Indian? It's very difficult to define. It can't be defined. I mean, to my mind, it's very difficult to define. In fact, as Mark Tully says, there is no full stops in India. You see, India is all the time, vibrant, going. Something is happening. It has been going on for thousands of years. But then, fortunately, we have a wonderful constitution. And this BR, I'm so happy to be privileged to be speaking in this university in the name of, which was established in the name of B.R. Ambedkar ji. As we all know, he was the kind of the chairperson of the drafting committee, obviously, and one of the most brilliant Indians at that time. Somebody told me he had about 16 PhD degrees in varied subjects, not only law, sociology, economics, political science, history, just any name, any subject. Such a brilliant mind. And what he said about Indian Constitution, he said, Constitution is not merely a lawyer's document, it is a vehicle of life. And its spirit always is the spirit of the age. What is this age? That's again I say, is it the modern age we are all familiar with? These are questions we all students of law, and I consider myself to a student of law, asking this question again and again. The resilience of this country, you can imagine, see, we were under the colonial rule for more than 100 years. As many of the speakers must have said also, I can understand from these summarization of these various topics, I could understand many aspects have been spoken about, the richness of our Indian tradition, our legal system, how in ancient times it was all based on this, the whole concept of dharma. See, dharma is actually derived from this word dhri. Sanskrit, I am not a very scholar, but somehow I studied Sanskrit in class 8 to 10. So a little bit of idea of Sanskrit, which has helped me immensely. It's such a fantastic language, is a root to so many of the source of the many Indian languages also. So the dharma is derived from this dhatu called dhri, dhri to hold. What makes something hold? Everything hold, dhri. Because that thing which holds others must be first of all stable. That thing which holds others must be also strong. And that thing which holds others also must be communicable or adjustable to everything what is there. Otherwise it will not hold. See, a magnet holds only the iron. Non-iron it will not hold. But the dharma holds everything. That's the... See, again I say, what is dharma again? They all say it's all religion, somebody is a religion or it's a way of life. Again, it's all concept, all amalgamated together. The justness, the righteousness, what is correct, what is appropriate to way of life, the all encompass in this concept of dharma again. This whole concept of dharma is again very difficult to explain. But it is so much rooted. That's why when we read Buddhism, the three things we said, Buddham Sharanam Gacchami, Dhammam Sharanam Gacchami, Sangham Dharmam Gacchami. But dharma, that in the second line, Dharmam Sharanam Gacchami. See, that dharma, in Buddhistic philosophy also, which is again, as you know, Indian philosophy is an atheistic philosophy. It doesn't believe in God. The Buddhists say that there is nothing called God. They're all ephemeral. There is nothing like that. What is true is salvation. Again, the whole concept of moksha, liberation. That's why I'm referring to this. You may think why I'm again going off tangent. The whole question of liberty, the whole question of freedom is so intertwined with this whole Indian ethos, the concept, the tradition, the philosophy. That's why when I say Indianization of legal system is not merely translating or redrafting of which is of course necessary also to bring it more in tune with our requirement, being relevant to our system. That's how all these new 3 laws also important. And of course, trying the entire justice delivery system to resonate with the people's requirement. We are very fortunate. We are students of law. We understand law. But how many are able to understand what law is? How many people are able to understand what constitution is? How many people actually know how court functions? That's why we have this Bollywood films, Jolly LLB. I mean, that's what people perceive. And once we go out of the system, we feel our Indian system is so fantastic. We are judges, lawyers, arguing in the court, and law students studying of law. It's so familiar. But if you go out of the system, walk on the street, just talk about Indian law and courses, they said, kya hai ye? Nahi karna hai. So alien. That's why I said Indianization of law, our law should be able to vibrate with the aspiration of the people. I consider it very important to remain connected with the people, their problems, their aspirations. Then I would say it's real Indianization also. But again, these are all, one perspective. Now, let's start from Constitution, because that's where we always start as lawyers, judges, legal fraternity, students of law. That's the most basic principle of law. Can anyone just recite this preamble? Can any law student? Yes. Preamble to the Constitution of India. I think she is the favorite, but so she's she's a very studious student, I can understand. I'm talking of somebody else sitting there. Preamble, bataiye na? Why you are? The preamble, the most important part of the Constitution of India. Yes, bataiye. अब ये मत देखिए, वो मत देखिए, don't share notes. हम बोलते आप खड़े हो जाइए. We'll do it together. We, the people of India, having solemnly resolved to constitute India into sovereign socialist democratic republic and secure to all its citizens justice, social, political, economic, liberty of thought, expression, faith, belief and worship, equality. Then God. And fraternity and assuring the dignity of individuals, of the nation, not the state, of the nation. Do hereby adopt, enact, and on this 26th of not January, November. January, आप तो 26 January देखते हैं ना, so it is 26 January. But it's related because from 26 January it was actually implemented. That's why we celebrate 26 January. We say it's Republic Day. आप लोग किताब पढ़ते हैं इतने, whenever you go to a bookshop, always read through, but you always skip the introduction, preface, which gives you an idea of the book. Most of us always skip. अरे preamble में क्या है? No question is going to be asked, है ना? Oh, you are assured that no question will be asked, so you don't read the preamble. But then, preamble is the reflection is the heart of the constitution. See, we the people of India, see that declaring ourselves. I mean, it has never happened in this country. This country has been ruled by Rajas and Maharajas. That the Mughals came, that the British came. So we have been always ruled. If you are students of history, व्यापारी व्यापार करते रहते हैं. The merchants continue their business. Whether they कहते हैं ये तो राजाओं का fight है. There is a battle between the kings. The people never participated. So it doesn't matter whosoever is the king. कभी आज राजा होगा, कोई सुल्तान होगा, कोई ब्रिटिश होगा, doesn't matter. That's how the mind is to the history. But then things change. I said, no, we must take upon ourselves our destiny, our goodness, our prosperity depends on ourselves. We must be involved in that. That's what we, the people of India. The British didn't pass this, so we said there are many questions. How did we become independent? He said, yes, we became independent because of the Freedom Act 1947. No, there's nothing like that. We attain ourselves. Now, if again, I read the preamble, the three, that liberty, equality, fraternity. French Revolution पढ़े आपके? You have studied French Revolution. So you thought that we copied from French Revolution? How many of you think that we had adopted from French Revolution these words? बताइए. Almost of you think that yes. But if you go down, actually, the whole concept of this liberty, equality, fraternity, justice is already deeply embedded in our Indian society, in our tradition. The students, there were some from the notice, are still there, I don't know. There were some students from the notice. Nagaland se tha ek, I don't know, they were not there. See, in the 2nd century, when the Roman Empire destroyed this temple, the most important institution among the Jews in Israel, the Jews, they protested. Of course, they were crushed. They went went various parts of the world. That's all we call Jewish diaspora. You find Jews all over the world, in the East, in Europe. Some of them also came to India. That time, they were accepted in India with the peculiar habits. If you have been to Kerala, you will still have this synagogue in Cochin, one of the oldest synagogues in the world. One of the oldest synagogues. Then when Persia was invaded, overrun by the forces, again the Zoroastrianism was destroyed. Some of them came to India again. They landed up in Gujarat, the same as Jews. They came by sea. They came here. Before the Islam, what we call, we as students of history, the Islamic, see the history, the Mughals and all this. Before that, there were already Muslims settled in Kerala through this sea route. They didn't come as invaders, as traders. They came, they settled, the Mopalas. They became part of this country, Kerala. They married their local women, settled there, continued their practice, Islam. They were practicing, they had their masjid. And we thought that Christianity came along the British. No. The John the Baptist, we are told that he had come to India also. See, and they were never turned away. So that the fraternity we talk of that the concept of fraternity. How do we have fraternity concept unless you accept them? We accept them, we are treated them as equals. And we never denied any justice to them. They were not treated with. So you see this, the liberty, they had the liberty to practice their own faith. See, the whole concept of justice, equality, liberty, fraternity, all you find already in our ethos. We adopted these words because we did not have English at that time. We were not English-speaking country. And these are the words which are used in French Revolution, popularized in the Renaissance. That's how, but then the ideas, the concept, the principles were already there in this country. I have been benefited by some few wonderful notes supplied by you also in view of the discussions which had taken place. I am thankful to Ashutosh ji also for giving an idea as to what had transpired. This note also mentioned about Sri Nani Palkhiwala, who once said, India is like a donkey carrying a sack of gold. It does not know what it is carrying, but is happy with a lord on its back. I mean, of course, this is, I had read it somewhere else also. See, India is a great tradition, Silk Route, it passes, all goes. So all these donkeys, the horses to carry these priceless, but they don't know actually. That's what, the Nani Palka has a great sense of humor. We have not understood our own tradition, the storehouse of knowledge which is available there, which we need to rediscover. That from that perspective, all the entire discussion which have taken place is of, I consider, of immense value. It's not very easy in the sense because we have been brought up in this Western tradition, Western concepts. Nevertheless, it is not too late to rediscover what is the great. See, obviously, when we have reached this height of intellectual height, as mentioned by Duggalji also, this discovery of zero. You don't just discover zero like that, from the sky. The whole evolution, the whole process of reasoning, rationalization, logical thinking. But how do you channelize this thought process? There must be certain rules and norms. How do you interpret various phenomena? There must be laws of interpretation. That's what, in fact, I am just reminded of the judgment rendered by Justice Kaju also. In this case, Ispat Industries Limited versus Commissioner of Customs, 2006, Volume 12, SCC 583. I just read out a few paragraphs from that, para 30. In this connection, we may also refer to the Guna Pradhan axiom of the Mimamsa principles of interpretation, which is our indigenous system of interpretation. It is deeply regrettable that in our courts of law, lawyers quote Maxwell and Craze, but nobody refers to the Mimamsa principles of interpretation. Few people in our country are aware about the great intellectual achievements of our ancestors and the intellectual treasury they have bequeathed to us. The Mimamsa principle of interpretation are part of that intellectual treasury, but it is distressing to note that apart from a reference to these principles in the judgment of Sir John Edge, Deed and Chief Justice of Allahabad High Court in Beni Prasad versus Harday Bibi, and in the judgments of one of us, while a judge of the Allahabad High Court, there has been almost no utilization of these principles even in our own country. I am talking of the judgment under 2006. And the Mimamsa principles evolved thousands of years before. I think it is really time to go back and try to understand the rich heritage. And this is indeed a very, worthwhile beginning, I'm sure, because I don't know, I haven't come across any other conference where it has been dedicated to understanding the rich past of our tradition. There are many aspects, and in fact, many of us, the Indian Constitution, I started again. If you go through this original Indian Constitution, I don't know how many of you have seen the original Indian Constitution. If not the original, at least a copy of that original Constitution. Each and every part of the Constitution starts with a painting depicting the rich Indian history, culture. That painting does not necessarily reflect the contents of the part, but each and every part of the Indian Constitution has a painting. From Buddhism to Hindu Ramayana, Mahabharata, various aspects of the rich tradition, and it was hand painted by Nandalal Bose and some other artist. Again, I mentioned, as have been discussed again and again, the entire, the ancient legal system was based on this whole concept of dharma. In fact, in Indian philosophy, dharma it pervades all aspects of life. Not only the legal system, but your family affairs, but the state affairs and your spiritual affairs also. That's how the importance of this dharma. The principle, I am not talking of as a concept, but the principles which underlines all our activities in our personal domain, in our public domain, interpersonal relationship, personal relationship with the ultimate. And the Vedas are considered as the first source of dharma. Dharma constitutes the foundation of all affairs in the world. Everything in this world is founded on dharma. It is therefore considered supreme. Commandments of dharma, like nature's law, admit of no meddling. It has been emphasized that those who exercise political power must wear the hand glove of dharma, and the principles of dharma governs every sphere of activity, including the governance of the country. In fact, see in Kautilya, whom all of you are so familiar with, he said that he used to advise, in the happiness of his subjects, the kings, that in the happiness of his subjects lies the king's happiness. In their welfare, his welfare. Whatever pleases him, he shall not consider as good, but whatever pleases the people, he shall consider as good. The whole concept, because see, we are all used to this absolute monarchy in the Western civilization. Absolute monarchy. This is the word which we find always with the students of history. And taxation also, what he says about taxation? He compared fair taxation to a honeybee gathering nectar without disturbing its petals, counseling rulers to levy taxes gently so that subjects and economy thrive together. That's the beauty. I mean, don't disturb too much. You don't overtax a person. That's the people revolt. You do it slowly, little bit. Tax it, but in slow, in little amount. That's how you collect. So these are something obviously we consider to be very, that's how the whole taxation, when we always see this financial comes, the budgetary, how much we are going to. And the concept of equality also in Rig Veda is samano matraha sarmitihi samani. What does it mean? No one is superior. No one is inferior. All are brothers marching forward to prosperity. See, the whole concept of equality. See, all, if you go read some of these, and Dugalji also referred to this Vasudeva Kutumbakam. I mean, the world is one family. The whole question, the concept of fraternity. Then in Indian Constitution also we have this, the directive principles of state policy, the duty of the state. I will not go into that. And this, we have this compulsory education. What is education after all? And education is the enlightenment of the people actually. That's how once you get educated, you understand what is right, what is wrong. See that very famous slokas we always, as students, asatoma sadgamaya. From ignorance lead me to truth. Tamaso jyotirgamaya. Tamasoma jyotirgamaya. From darkness lead me to light. Mritturma mritam gamaya. From death lead me to immortality. See, all these slokas chanting, it's, from leaders from ignorance to truth, from darkness to light. These are all concepts, all deeply rooted in our thought process. That's why all these reservation policies also. Good for all. What is the whole concept? Again, this is a very mantra, this is a Vedic chanting, we must have Om Sarve Bhavantu Sukhina. May all be happy. Sarve Santu Niramaya. May all be free from diseases. Sarve Vadrani Pashyantu. May all see things auspicious. Ma Kaschit Duga Bhagavad. No one be subjected to misery. They are from these Upanishadic principles. So what I am trying to say is many of these are already ingrained in our constitution, but we do not realize that. Why I am saying so, why I refer to this is because unless we are able to see the connection between our past, which we will be able to do it only when we study, do more research, then we see the relevance of these principles contained in the Constitution of India. Then we feel more connected. Because there is still a criticism that Constitution is still an alien kind of document. But it is not really so. If we study our Indian history, our rich past tradition, we see a lot of connectivity, connection with our past. But many of us have not really done deep research in this work, and which I feel is very important to make us make this constitution and legal system more relevant. I will not quote much of this already judgments which have been also referred. I am sure how our Indian legal system, judiciary is trying to respond to the new challenges, requirements of the day. I mean, this whole new criminal laws which have been enacted is an attempt to position ourselves, make it relevant to our requirement of the day. Much have been spoken about it. Yet there are still many challenges before us. There are still many acts which have colonial origin. Those in the notice would know that Armed Forces Special Power Act, a lot of questions, issues are raised as to whether it is compatible with the democratic principles, because Armed Forces Power Act, initially it was said that he can be picked up without any reason. The armed forces have the power, even and use force to the extent of causing death. Of course, these provisions have been interpreted by the courts by saying that no, merely because you can be picked up by, because normally it is the police who can arrest, not the army. The army has been given the power, even use force to the extent of causing death. Whether it is possible, whether it is commensurate with our constitutional mandate, these are questions being asked. Then, of course, as I mentioned again, the client who sits in the courtroom doesn't really understand what is happening between the conversation between the lawyer and the judge. Is absolutely alien. They're all Greek and Latin to them. All these issues of res judicata, these lawyers are talking about res judicata and all that. What is res judicata? They don't understand anything. There's so many, of course, you can't avoid using these terminologies, of course, but then how do you make it more easily understandable to the client? Because it is their cases which are fighting. We are just intermediaries actually. And the client sitting behind is, thinking, what will happen to my case? Is the judge going to pass an order which is favorable? Because he is not interested in all the verbose and all those big arguments which he put forth. He is only interested in getting some kind of relief. Are we able to see? There is an alienation, there is a gap between our system and understanding of the people. There is a big challenge before. That's why also I could say Indianization of the legal system means being easily understandable to the client, to the people. And of course, thankfully, the Supreme Court also with this new use of technology, we have been able to make available the judgment in 16 languages. Earlier only English. But the judgment in English written can be read by anyone in some of the local languages, in Marathi, in Bengali, in Oriya, in Assamese, Kannada. So they're all being translated with the use of AI. That's also a very important limb, the use of technology, which has been also a subject matter of which Dukhalji also an expert in this technology. But these are areas where it can enhance Indianization of the legal system. When I say Indianization, means making relevant to the common man. That's what really it actually means. Not merely using the principles also, but making it relevant, understandable. That's what Indianization. Then, of course, again, it's a vast country. Every state, somehow has different unique customary practices again. If you go to Northeast, where I come from, we have the students you will have the 6th schedule. Can anybody say about 6th schedule? No. 6th schedule of the Constitution of India. A very unique provision to protect especially the tribals in the Northeast area. That they feel that because of the sheer number, and they feel that being a minority, they will be overwhelmed. So they were given some kind of assurance. No, you will be able to still practice your customary practices. It will be protected. In brief, that's the 6th schedule. But again, India is India. You can't India divide into these narrow domestic walls. That's what Rabindranath Tagore has been in his Where the Mind is Without Fear. In the beautiful lines, no? Where the mind is without fear, where the world is not divided into narrow domestic walls. We must be, when we say Indianization, then we must be all together again. With all the different colors we wear, different dresses we wear, different languages we speak, different foods we eat, we must remain a same Indian, which is embodied by the constitutional vision, the Constitution. We must have unity in this diversity. How do you ensure that? That is another big challenge. And customary law, what we have seen is that unfortunately, because of the stage of the social development, it has been found to be mostly unfair to women. Many of these customary laws are very unfair. You don't have any inheritance rights given to women. That is true also of the majority also. Hindu marriage under the Hindu Succession Act, it was very recently. Earlier in the traditional law, women were not allowed this, the inheritance right was not there. So you can imagine the small communities also. But then this is frowned upon by the Constitution. If you read Article 13 of the Constitution, what does it say? Any act, any law, which is repugnant to any of the parts, that is the part 3, to that extent it will be void. And law has been defined as, law includes regulations, ordinances, acts, usages, customs and usages prevalent. Therefore, if there be any custom which is violative of the fundamental right, which is Article 14, 15, 19, etc., 21, equality clause, to that extent it will be void. So we have to make sure that while we respect the customs of the people, we cannot allow any customary law which is patently discriminatory as against women or any other section of the society. In Nagaland, I had decided a case when I was in Guwahati High Court. There was a case which very interesting case. The village decided that there will be only one candidate in their election, MLA. That Mr. So-and-so, he will contest from this village, nobody else. The villagers, the headmen, elders. Then another village said, why should I? I don't believe in this fellow. I don't know. I will also contest. He filed his nomination. Then when he filed his nomination and he won also, the villagers said, you defied our dicta. You shall be excommunicated. Then he filed a case before the High Court. So how can they excommunicate me? I have a right to contest the election. It's my fundamental right. So I had to decide this. There's this customary law because, okay, I understand the village elders, you have the final authority to manage the affairs of your society, your village. But if it violates the fundamental right which is guaranteed by the Constitution of India, right to equality, to that extent it is void. So we quashed it. So what I'm trying to say is that, see, I'm just giving an example, but there may be an untold number of cases, instances in various parts of the country where customs are practiced, but they are apparently and contradictory to our constitutional norms, constitutional values, more particularly fundamental right. Then in that case, yes, these are unconstitutional. We must, merely because it is part of our tradition, no. So when we say the tradition, Indianness, we must also stand up and see whether our traditions, our belief, our practices are in tune with our constitutional norms. If not, then we must abjure it. That's also Indianness. Therefore, these are all areas I'm sure must have been discussed in some of these papers also. In fact, then how do we go about? First of all, yes, we must do a lot of research to find out to how to Indianize the legal system, as I mentioned again. How do you make it relevant to the people, accessible to the people, understand the legal system, which is so complicated, and also reflects the need of the people. And very important, this Mediation Act 2023. There is a very important chapter 10, if I am not mistaken. Section 43 of the Mediation Act, if you go through, there is a provision for community mediation. It provides that if there is a difference, the dispute arising anywhere in the community, amongst the families, then there can be mediation at the community level, where not only lawyers and judges, retired judges, but also normal other members of the society who command respect can be also, their help can be also invoked to act as a mediation. What I'm trying to say is that, see, these are also part of Indianization, because, see, we have this whole great tradition of resolving disputes in our locality, in our family, through mediation and conciliation. And this has been given statutory force with incorporation of Section 43 in the Mediation Act 2023. This is also another attempt, or what I would consider to be Indianize the legal system. These are all part of the views, very interesting, which are coming up. I think I am overshooting the time. I do not wish to already make it a long day. You had a wonderful discussion of many scholars who have spoken on this podium. I said, yes, when we say Indianization, it's not going back to the past blindly. We must pick up those which is good for us and leave aside which does not conform to modern ideas also. Because see, we are living in today's modern world. We can't live in the past only. While we take great pride in our great tradition of the past, we must look ahead. As I say, in fact, the third part of this session on technological advancement and the use of technology. As a student of history, I have noticed how the colonialism came. This country, the world over, these great civilizations. You have this Indus Valley civilization. We don't know how Indus Valley civilization has vanished. Still is a mystery. Egyptian civilization has vanished. One of the greatest. Mesopotamian civilization. You have Mayan civilization in South Africa, in Latin America. Great civilizations have thrived. Many of them have perished. But what makes a civilization thrive is because we are able to remain relevant to the present need and challenges. And one of the greatest challenges is going to be the AI. The Western civilization dominated the rest of the world by colonizing the rest of the world, African, Asian, and Latin American countries by sheer power of industrial power, industrial revolution, use of gunpowder, use of steam engine. To this sheer industrialization, they dominated the entire rest of the world. The greatest challenge today is use of AI technology. If we are not able to adapt ourselves to the new challenge, the one which controls this AI is going to control our lives. Not only our lives, but all other affairs of the country. Therefore, legal system was a big challenge for us also. And many questions are being, in fact, is a big debate going on within our judicial system also. In our conferences we hold regularly, there is a specific topic on this, the use of AI in judicial system. A big challenge for us. First of all, AI doesn't have any heart, isn't it? AI doesn't have any heart. AI is a basic machine, pure machine, very efficient machine. But judge cannot be merely pure, a very efficient judge. To be an efficient, good judge, he must be also a good judge. Understanding the pain, suffering, difficulties of a live human being. When we function as judge, we are not deciding we are not making some experiment, laboratory experiment in the laboratory as scientists would do. The students of science, biology, I have done myself how we cut the frogs and to understand this dissection class used to have practical class. Unmindful of the suffering of this frog, he said, see, the teacher would show us, this is the heart, the thriving, You can't do that with human beings. Maybe you can experiment with animals or plants, but not with human beings. You must have that empathy for the suffering of the human beings. You must have sympathy, understanding. How do you do that in AI? Therefore, AI, as in the judicial world, it has been ruled out as a part of a judicial making, but it can be used for the purpose of using which does not involve too much of human emotions. That's why even El Salvador, in some countries also, they are using for deciding tenancy related cases or motor accident kind of cases. where it doesn't involve too much of appreciating, understanding, affecting the human aspects of life. So AI, but it can be used, as I mentioned again, to make it relevant to the people, translation, and making all these voluminous case laws in a simple forms to make it understandable, to save time. In fact, the Supreme Court is also trying to evolve this software by which, we have to go through hundreds of pages every day, case laws and drafting, pleadings. How do we get a summary of that? Because if you go through each and every page, it will be practically impossible. So this software will help us. For example, in a trial case, there are many evidences, goes for pages. So this AI will find out which is the most relevant to the issue. What is the most relevant? So it will pick up and place it before the judge. And irrelevant matters will not be. So it will save a lot of time for us. So these are ways in which AI can be used, utilized. There are many other ways which have been already discussed. Thank you very much for giving this opportunity. This is a topic. This is a subject which is of immense importance and I would say, and we are going in a very kind of in which a lot of research is required to be conducted, and a lot of research. I'm sure with the wealth, the kind of wealth we have in the past, in our tradition, we'll be able to refine our whole concept, our constitutional principles, make it more relevant and in tune with the people's aspiration. Thank you very much.
Thank you, Lordships, for the enlightening address. On a lighter note, I don't think we'll ever forget a word of the preamble. As the profound resonance of His Lordship's address continues to resonate, we are deeply grateful for the wealth of wisdom and resolute dedication He has shared with us today. His dynamic discourse, meted out to us, has not only ignited a spark of inspiration with each of us today, but also reaffirmed a shared commitment to pushing the boundaries of knowledge and excellence in academia. We extend our sincerest appreciation for the magnanimous contribution he has made to today's conference.
As we draw this conference to a close, in honor of your distinguished presence and invaluable contributions, we are proud to present this token of appreciation. A symbol of our deepest gratitude and respect, may this memento stand as a lasting reminder for the connections we have forged and the insights we have shared, reflecting our collective commitment to collaboration, transformation, excellence, and progress.
Now, I humbly request our patron-in-chief, the Honorable Vice-Chancellor of the University, to felicitate our chief guest, Honorable Mr. Justice N. Kotiswar Singh Ji, Judge, Supreme Court of India. I again request Honorable VC Sir to extend memento to a special guest of honor, Honorable Mrs. Justice Meenakshi Mehta Ji, Judge, Punjab and Haryana High Court. I again request VC Sir to present memento to Honorable Mr. Justice Pankaj Jain Ji, Judge, Punjab and Haryana High Court. I request Registrar Sir to please present the memento to Dr. Pavan Duggal Ji. With great reverence, I request our chief guest, Honorable Mr. Justice N. Kotiswar Singh Ji, to felicitate our Vice Chancellor. I request His Lordship to kindly facilitate our conference director, Professor Ashutosh Mishra Ji.
As we draw this remarkable conference to a close, it is time to express our heartfelt gratitude to all those who made it a resounding success. To extend the formal vote of thanks, we now invite a distinguished academician, a dedicated administrator, and a guiding force behind this conference, Professor Dr. Ashutosh Mishra, Registrar of the University and Director of the conference. We request Sir to kindly take the stage and offer vote of thanks. Can we have a huge round of applause for Sir?
On behalf of on behalf of Dr. B.R. Ambedkar National Law University, I extend my sincere gratitude to all eminent dignitaries, participants for gracing the valedictory ceremony of this remarkable and successful National Conference on Legal System. Deeply honored to our chief guest, sir, Honorable Mr. Justice N. Koteshwar Singh, Judge, Supreme Court of India, for giving precious time. And I just want to share to all of you कि सर आज सुबह श्रीनगर में थे और ओनली फॉर दिस प्रोग्राम सर ने अपने प्रोग्राम को चेंज किया और वो इस प्रोग्राम में पार्टिसिपेट हुए हैं. आप सबने सर की स्पीच सुनी हुई है, अभी आपने खुद ऑब्जर्व किया है, क्योंकि मैं सर को पिछले 4 सालों से मैं कहीं ना कहीं मैं इनवाइट करता रहता हूँ. He was judge in Guwahati High Court, and basically I can say that, I must say that he is a jurist of the contemporary legal system. बेसिकली सर का सुबह फ़ोन आता है, एक तो सर ने कहा कि मैं श्रीनगर से आना पड़ेगा, पता नहीं, मैं आई विल कंफर्म यू। जब सर का फ़ोन आया तो मुझे फिर ये डर लगा कहीं सर आ तो नहीं रहे हैं। एक बार फ़ोन आया, फिर दोबारा मुझे लगा सर का कैंसिल हो रहा है, लेकिन सर ने ये कहा कि आशुतोष जी जो ये पेपर्स आ रहे हैं वो आप ज़रूर देना मुझे, क्योंकि मुझे उसको देखना है और उसको देख करके मैं थोड़ी अपनी स्पीच में तैयार करूँगा। वी मस्ट अप्रिशिएट हिज कमिटमेंट। बेसिकली ही इज़ academician by heart, है ना। तो सर, वी ऑल आर वेरी थैंकफुल टू यू फॉर गिविंग प्रेशियस टाइम। आई एम heartfelt gratitude to our special guest of honor, Honorable Miss Justice Meenakshi Mehta ma'am. Ma'am has given precious time to all of us. Ma'am, NLU Sonipat is grateful to you. Sincerely thankful to our special guest of honor, Honorable Mr. Justice Pankaj Jain, Judge Punjab and Haryana High Court. Sir has given his precious time. Sir is coming from Chandigarh only to attend this program. Sir, we all are highly grateful. I am very thankful to Honorable Vice Chancellor, sir. He is a very visionary and his guidance has made this conference a very successful. I have seen that from last 10 days, he is 24/7, he is involved and he is guiding us in all aspects. Thankful to all organizing partners. I am thankful to all teaching faculty members, Dr. Pooja, Dr. Balwinder, Dr. Madhukar, Dr. Sanjay, Dr. Kulwant, and Mr. Navneet, and to all other faculty members. Thankful to all non-teaching members, all the branch head, Dr. Ramphul, Dr. Mangla, and Mr. Rajesh, Mr. Sandeep, Mr. Krishan. Thankful to all other members, and I am thankful to all the students. These students, basically, students have played the most important role. I must say, हम लोग तो खैर ऊपर के लोग हैं, वीसी सर हैं, हम लोग हैं, पूजा मैम हैं, सब लोग हैं, लेकिन इस कॉन्फ्रेंस में जो मोस्ट इम्पॉर्टेंट रोल है वो स्टूडेंट्स का है। एंड आई मस्ट शेयर देयर नेम ऑल्सो। मिस्टर राजीव, अर्पित, हृदयांश, पार्थ, नव्या, इशिता, कायरा, सिद्धम, शुभम, सार्थक, अदीब, एंड पीएचडी के स्टूडेंट्स हैं दीपक चौधरी एंड अपूर्वा। बेसिकली अभी मैंने सर से भी, पवन दुग्गल सर से भी कहा कि सर ये स्टूडेंट्स जो हैं बहुत ही अच्छे हैं, आप एनएलयू से बच्चे, आप इनको इंटर्नशिप में और जॉब में रखो। इन्होंने अभी कहा कि आप जिनको जिनको भेजोगे आई विल टेक, एंड आई मस्ट रिक्वेस्ट टू ऑनरेबल जस्टिस कोटेश्वर सिंह सर ऑल्सो कि हमारे यहाँ के जो एक दो बच्चे हैं आप उनको इंटर्नशिप में आप ज़रूर लीजिए। और ऑनरेबल जस्टिस फ्रॉम पंजाब एंड हरियाणा हाई कोर्ट, जस्टिस पंकज जैन एंड जस्टिस मीनाक्षी मेहता मैम से भी मैं रिक्वेस्ट करूँगा। एंड थैंकफुल टू ऑल ऑफ यू, एंड जय हिंद, जय भारत।
Thank you, sir. Distinguished guests, as we bring this conference to a close, I'm reminded of the profound responsibility we bear in shaping a legal system that is truly Indian in spirit and practice. A journey towards Indianization is not merely about renaming laws or changing procedures. It is about infusing a legal framework with the values that have defined a civilization for millennia. Values of dharma, justice and equity. Let us pledge to make our courts places where every individual, regardless of their background, can seek and receive justice and dignity. As we look to the future, let us draw inspiration from our past to create a legal system that is both modern and deeply rooted in our traditions. May our efforts lead to judiciary that is transparent, efficient, and above all, just. In words of our ancient scriptures, Swasti Praja Gyane Nyayo Marge Mahisha. May the rulers protect the earth through the path of justice. Thank you. May I now request you to kindly rise for the national anthem.
जनगणमन अधिनायक जय भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय
A group photo, sir.
We'll give a compensatory break for today. Most probably 28th.